Good morning, friends. Today we're looking at beyond reasonable doubt, and specifically I'm going to first cover an introduction. All right, if we're defining it, beyond reasonable doubt is a phrase that is no doubt familiar to most people, even people who are not involved in the legal industry and are fortunate enough to have avoided close contact with the criminal justice system. They've probably heard the phrase and know that it is the standard of proof applied in criminal trials. Now, indisputably, the phrase has well and truly entered the arena of the common person. But how many people know what it actually means? They should know. After all, it is, for example, in countries like Australia, it is the jury who have to apply the standard, and in Fiji, the judges that do that. And it is up to the judge or jury to make up exclusively of common everyday people. Now, if they're made up of common everyday people, they need to understand what this term means. Now, the courts assume at times that jurors know what the phrase means, and that is why they refuse to define the phrase or guide jurors in their application of the standard. Now, this to me is a little bizarre, because judges themselves struggle to adequately define the phrase and explain it to each other. Now, I've got an Australian law degree and I've got a background in law in Australia. So in looking at the Australian perspective, the common law of Australia features disagreement between judges about what the phrase actually means. Does it mean any doubt? Because any doubt a juror entertains is by definition reasonable? Or does the phrase necessarily require a juror to internally analyze their doubts and categorize each one as either reasonable or unreasonable? If there is confusion amongst judges, how can the phrase then be regarded as self-explanatory to a lay jury person or a lay person? The empirical research suggests that jurors do not understand the concept of beyond reasonable doubt in the way that the court assumes they do. Most of the evidence suggests that jurors apply a lower standard than what judges would deem acceptable. And some of the studies and research I came across show, investigations that the effects of different definitions have also shown that by varying how the concept is explained, the standard of proof that is actually applied by jurors can be raised or lowered and ultimately affect the verdict of a trial. Now, this has powerful implications. For example, Victorian law, right? Victorians' position against defining the concept of beyond reasonable doubt. It suggests that by failing to provide jurors with a more detailed and useful explanation of the standard of proof, the court may unwittingly be lowering the standard of proof being applied beneath an acceptable level. Now, rather than lowering the standard of proof as the court fears, empirical studies actually indicate that defining or explaining the standard of proof can raise the standard of proof that jurors apply to a point that better reflects the high bar of proof that the concept originally intended. And that judges require Victoria, for example, should therefore take steps similar to that in other jurisdictions, allowing or even requiring judges to make an adequate definition of beyond reasonable doubt in their charge to the jury. Now, I'm going to be looking at more of this, but I'm going to be looking at the historical and modern concept of beyond reasonable doubt as well, which I'm hoping will briefly explore this area. Then I'm going to move on to analyze the common law and legislative framework around the standard of proof as it applies to criminal trials, for example, in a state like Victoria. Now, I keep referring to Victoria because I have been admitted to the Supreme Court of Victoria initially. I'm then going to go on and look at the empirical research into juror comprehension of this phrase, beyond reasonable doubt, and the effect of different definitions on how jurors apply this standard, the standard of proof. The limitations of jury surveys and mock trials. I'm going to be looking at some mock trials, as well as drawing together the research and some information I've found, looking at the question of whether we should define reasonable doubt in a state like Victoria, which will then impact on Fiji as well. And out of interest, I'd like to also look at England and Wales, Canada, US, and then coming across in applying it to Fiji. So let's look at a brief history to understand beyond reasonable doubt. Now, the concept of beyond reasonable doubt being the standard required by the common law to convict a person of a criminal offence came about in the 16th century as juries gradually became unable to simply rely on personal knowledge of the events in question. Now, it therefore became necessary for judges to set a standard of assurance that jurors were required to meet before they could convict a defendant. It was the judges of the 16th, 17th, and 18th century that undertook this task with little help from the earlier common law. Now, I've come across a piece here by Professor Shapiro, who suggests, and by the way, all of this will be cited at the end of the presentation. Professor Shapiro suggests that judges, therefore, turn to the epistemology that was available at the time from religious doctrine and philosophy. Now, that's interesting. She argues that the phrase beyond reasonable doubt was born from an attempt to build an intermediate level of knowledge, short of absolute certainty but above the level of mere opinion. Now, part of the philosophy on which the concept of reasonable doubt is based is the distinction between two realms of human knowledge. In one of these realms, it is possible to obtain absolute or mathematical certainty, whereas in the other empirical realm, such mathematical certainty is not possible. I mean, if we go back and look at John Locke, I mean, I covered John Locke when I was studying political science back in 98, 99. John Locke's an essay concerning human understanding, I think it's a 1690 essay, I will verify that before I put that in citation, was influential in this regard because we see past events of human behavior belong in the empirical realm. In this empirical realm, there are different levels of certainty, the higher of which can be achieved as the certainty and quality of evidence increases. Now, the highest level of certainty available in this empirical realm is the level required before a defendant may be convicted of a crime and was traditionally called moral certainty, which is a certainty that shows there was no reasonable doubt. Now, looking at the modern concept of reasonable doubt, the Lockean origins of beyond reasonable doubt are still reflected in the standard of proof today. It is clear that the discussion of the Australian common law, courts still base their understanding of the concept on the idea that in a criminal trial, guilt can never be proven with absolute mathematical certainty. But nevertheless, an especially high bar of confidence should be imposed before a jury may convict the accused. Now, the standard of proof, or the standard of beyond reasonable doubt, has been around for so long now that it is a term probably familiar to most people. I mean, we see it in in TV series, Law and Order, crime movies, novels, and so forth. Now, if you haven't heard it in a courtroom, you've probably also come across it not just in TV and books, but in everyday conversation, everyday life. The High Court has commented that the expression is used by ordinary people and is understood well enough by the average man in the community, leading the court to suggest that the term does not need to be defined in order to be understood by a lay person or a lay jury person. However, I feel familiarity and the use of the phrase is one thing, okay? But understanding and applying the ancient meaning of the phrase in the criminal law context is another thing altogether. And I think it's very important if we're going to be applying it in law. The common law of Australia would suggest there is no gap between the two, okay? And that jurors inherently understand the term as meaning the highest form of proof in the empirical realm of human knowledge. Now, I'm going to attempt to dispel that notion, also with reference to psychological studies that suggest modern juries do not have an inherent understanding of the term as it was originally intended. So, going back to Victoria, I'd like to look at Victorian jury directions on beyond reasonable doubt. Now, firstly, let's look at the common law position, okay? To define it or not to define it. Now, essentially, the common law of Australia directs that no further elaboration on the phrase beyond reasonable doubt is required. If we look at a case, Thomas and the Queen, Justice Kitto is often quoted from that particular case. And this is what it says: whether a doubt is reasonable is for the jury to say, and the danger that invests an attempt to explain what reasonable means is that the attempt not only may prove unhelpful, but may obscure the vital point that the accused must be given the benefit of any doubt which the jury considers reasonable. Now, the starting point to understand the common law's position on what beyond reasonable doubt actually means is the judgment of the High Court in Green and the Queen, okay, known as Green commonly. In a joint judgment, Chief Justice Barwick and Justices McTimmon and Owen defined reasonable doubt as follows: a doubt which the particular jury entertain in the circumstances. Jurymen themselves set the standard of what is reasonable in the circumstances. A reasonable doubt which a jury may entertain is not to be confined to a rational doubt or a doubt founded on reason in the analytical sense. Now, this passage, which apparently equates a reasonable doubt to a doubt, was in response to a direction from the trial judge that the jury was required to consider the quality of any doubts they might have and determine whether they were rational or otherwise. As is indicated by that passage, the High Court determined that such an instruction requiring jurors to analyze their mental processes was erroneous. The judge in the Green case the judgment in the Green case, if we look at it, it allows for a judge to exclude fantastic and unreal possibilities as sources of reasonable doubt, but only where necessary in order to remedy an imbalance in the trial. That is, where the defendant's counsel excessively labored the onus and standard of proof to such a degree that the jury may be misled into thinking that such unreal possibilities ought to be regarded as reasonable doubts. The direction in that Green case, that the phrase reasonable doubt means any doubt or, a jury person may entertain, and that the court should not instruct the jury to subject their doubts to any kind of objective internal analysis, has caused confusion and debate in lower courts. Now, the debate centers on whether the court intended what it appeared to imply in the Green case, that any doubt that might occur to a jury person is a reasonable doubt, whether or not that doubt could objectively be described as reasonable. Now, I've got another case here from South Australia. Okay, let me have a look. In the South Australian case of the Crown against Wilson, Chief Justice King delivered a judgment reaffirming the High Court's direction that no further elaboration to beyond reasonable doubt is necessary, and that any direction requiring the jury to assess the quality of their doubts is defective. According to Chief Justice King, if a jury has a doubt at the end of their deliberations, that doubt is ipso facto, which is a reasonable doubt. So Chief Justice King confirmed this view in another case, the Crown and Pahuja, where Justice Johnston agreed, stating that if a jury entertains a doubt, such a doubt is a reasonable doubt. And he says, by definition, because it is entertained by the body of the jury, which in our constitutional concept and tradition is the embodiment of the reasonableness of the numbers of the society whom the jury represent. Now, it's interesting to note that in that particular case, Justice Cox dissented. Okay? Now, he regarded it as self-evident that the word reasonable in the phrase beyond reasonable doubt is a word of limitation. He argued that the word reasonable is not superfluous and that it therefore must imply that there are some doubts that are reasonable and other doubts that are not. Now, Justice Cox also sees it as not only being possible but inevitable that on occasion jurors may have unreasonable thoughts or make unreasonable judgments, which you and I can understand here, right? We do that in everyday life. And therefore, Justice Cox felt that a degree of analysis and evaluation about whether a doubt is reasonable or otherwise is inseparable from the concept of beyond reasonable doubt. Now, Justice Cox argues that the judgment in Green's case, can be reconciled with his views when one acknowledges a distinction between the jury's corporate state of mind when deciding on a verdict and the internal mental process of individual jurors determining whether a doubt is reasonable or not. Now, Justice Cox suggests that in the Green case, when the High Court asserted that a doubt is any doubt that the jury entertains in the circumstances, the court was referring to the corporate state of mind of the jury, not the evaluative process of considering and discarding unreasonable doubts that may occur in a juror's mind. Okay, now that is important. Justice Cox also concedes, in line with Green, that it is understandably confusing as well as unnecessary and undesirable to invite the jury to expressly to go through such an exercise of systematically evaluating the reasonableness of their doubts. Now, the Victorian Court of Criminal Appeal has approved Justice Cox's interpretation in a case known as Neelan against the Crown and the Crown against Chatstannet, but again reiterated that the jurors set the standard of what is reasonable, and that there is an understanding and an undesirability of seeking to explain to a jury what is meant by the phrase beyond reasonable doubt, except by way of contrasting it with the standard of proof in civil proceedings. The common law position on the definition of the concept of beyond reasonable doubt can therefore be summarized as follows. Okay, so judges should refrain from giving any further directions than simply saying the jury must be satisfied beyond reasonable doubt, or by simply comparing the criminal standard to its civil counterpart, unless they are asked by the jury what the phrase means. In that case, the judge should perhaps say it is up to the jury to determine for themselves what doubt is reasonable. Now, it is acknowledged by the meaning of Justice Cox and the Victorian cases that approve of it, that jurors necessarily weigh up the reasonableness of their doubts. However, the trial judge should not instruct the jury that they are to engage in such internal analysis. Look, it just may happen organically. The jury would have to be directed in a certain way. But if we're looking specifically at Victoria, where I'm from, we've got an act there. It is the Jury Directions Act 2015. Now, that actually gives further guidance on what judges may say in regards to the concept of beyond reasonable doubt. However, as it is neither prescriptive nor proscriptive, it is important to, keep the common law in mind when considering how judges are permitted to instruct juries on the standard of proof in criminal trials. Right, now I'd like to look at the legislative approach. Okay. Jury directions in Victoria are governed by the Jury Directions Act, like we've just looked at. Now, specifically speaking, Section 63, subsection 1, provides that a trial judge may provide the jury with an explanation of the phrase proof beyond reasonable doubt if the jury directly asks a question about the meaning of the phrase, or a question indirectly raises the issue of the phrase's meaning. Now, pursuant to Section 64.1, if such a question is asked, a judge is permitted to, firstly, refer to the presumption of innocence, or indicate that it is insufficient for the prosecution to persuade the jury that the accused is probably guilty or very likely guilty, or acknowledge that it is most impossible to prove anything with absolute certainty when reconstructing past events, and that the prosecution does not need to do so, or state that the jury cannot return a guilty verdict if they have a reasonable doubt about the defendant's guilt or the accused's guilt, or the judge may indicate that a reasonable doubt is not an imaginary or fanciful doubt or an unrealistic possibility. Now, Section 63.2, subsection 2, provides that the provision in section 63, subsection 1, allowing a judge to give directions on the standard of proof when a question arises, it is an issue and it does not limit any other power of a judge. Therefore, judges have the power to give the directions outlined by section 64, subsection 1, or any other direction permitted by the common law without the jury first asking a question, although recall the position of the common law is discouraging of trial judges providing an explanation of beyond reasonable doubt unless the jury asks a question that requires an explanation, or the explanation only compares the criminal and civil standards of proof. The legislative framework does not differ greatly, I think, from the common law explored, because it is neither prescriptive or proscriptive, leaving that instead to the common law itself. The legislative approach and the legislation here appears to merely codify some of the directions that the common law has deemed acceptable. And I mean, the legislation also appears to leave it open to the common law to govern in what circumstances an explanation of the standard may be given. Now, under section 64, a judge may only give the directions outlined if they have been asked a question which directly or indirectly raises the issue of the standard of proof. Section 63, subsection 2, only allows judges to give directions whether a question is being asked in circumstances that the common law would follow. Now, moving on, I'd like to look at some psychological research into jury directions on the standard of proof, and we will look at its implications as well. All right. Now, the legislative and common law approach to defining or not defining the standard of proof tells us what the Parliament and the courts think about jurors. Okay, so understanding the concept of beyond reasonable doubt. But what does the research tell us? Unfortunately, the research conducted by jurists and psychologists provides quite mixed results, okay? And again, the sources and citations will be shared at the end of this presentation, so you can go and do the research yourself as well. It appears to me that whilst most studies suggest that the majority of jurors do not understand the phrase beyond reasonable doubt as it is intended, studies differ over whether jurors are more lenient or stringent in their application of the standard of proof. Now, studies have also demonstrated that the standard of proof applied by jurors can vary depending on the wording of the definition or explanation of the standard of proof. And together, these findings have powerful implications on what the law's position on explaining the phrase beyond reasonable doubt should be. If jurors fail to comprehend the standard of proof, and the explanation of the standard can affect how it is applied, then surely we must carefully consider the need to incorporate a more consistent, in-depth definition for beyond reasonable doubt. Now, before getting into the detail of what the empirical research says about jurors' understanding of beyond reasonable doubt, the limitations of these studies referred to should be acknowledged here, okay? So if we look at, let's now go into looking at the limitations of studies, but we're going to look at how it affects mock trials or mock juries. All of the studies referred to so far and henceforth are either studies of mock juries, that is, experiment participants who volunteer to be part of a study but are not actually jurors, or they are actual jurors being interviewed after their jury duty. Okay, now neither of these perfectly represents an actual jury, just so you're aware. If we look at, there's a reading here I'm going to be sharing in the citations. Diamond and Cecil. It's a 1974 text. Now, they conducted a study where they used mock juries randomly selected from a pool of eligible jurors to sit in on real criminal cases before then comparing the verdicts of the mock jury with the verdict of the real jury. Now, the results of the study indicated the mock jury would have given a guilty verdict in 10 out of the 10 trials. This was then compared to the real jury, which found the accused guilty in 5 of the 10 trials and not guilty in the other trials, in the other 5 trials. So this led the researchers to conclude that real jurors interpret the standard of proof to be a higher threshold than mock jurors who are fully aware that their decision is not binding on the defendant. Now, it is for this reason that researchers of mock trials state their results should be considered suggestive rather than definitive. Interviews of real jurors after their jury duty is completed should also be taken with a grain of salt, and I say that with respect. The jurors are not observed during their deliberations, and there is no way of knowing for certain that what they tell a surveyor accurately represents what they actually did in the jury room. However, mock jurors and exit interviews are so far the only methods by which researchers can empirically study jurors. Even though a study of a real jury is theoretically possible, the legal, ethical, and practical constraints have so far proven insurmountable. Now, I think this is a very important consideration for Fiji. I mean, we don't have a jury per se, but we've got assessors in the High Court. And this should be treated in the same way. It carries the same weight. And we need a system of, checks, balances, and control while the assessors are deliberating away from the courtroom and away from defense and prosecution, to see how they come to that reasoning when they consider the concept of beyond reasonable doubt. Which brings me to the question, do juries or assessors actually understand the phrase beyond reasonable doubt? Now, one would think that the phrase, or one would think that the given the preference of, for example, Australian courts not to define or provide any further elaboration on the phrase beyond a reasonable doubt, that it is a simple matter of fact that jurors correctly understand and apply that phrase as the standard of proof. Now, some legal scholars argue that jurors have, or assessors would have, an original understanding of the phrase, and therefore further definition is necessary. However, studies of mock juries and surveys of actual jurors indicate that this may not be the case both in Australian and Fijian jurisdiction. Now, if we look at another case I found here, Kerr et al., so Kerr and others, 1976. Now, they conducted a study of how different definitions of reasonable doubt affected mock juries made up of college students. The study revealed that the mock juries who were not provided a definition of reasonable doubt suffered greater group disagreement and individual uncertainty over the verdict, resulting in more hung juries from the groups where reasonable doubt was defined. Now, if we look at a piece here, I'm going to share Horowitz and Kirkpatrick, 1996. Now, they conducted a study where 80 mock juries made up of 6 people each heard 1 out of 5 possible instructions relating to the standard of proof required for conviction in a trial that either had strong evidence suggesting guilt, it was a strong case, or a favored acquittal, which was a weak case. Okay? Now, part of the study required jurors to provide a numerical indication before and after deliberation of the certainty of guilt that the standard of proof required before they could convict the defendant. When the phrase beyond reasonable doubt was left undefined, listen to this. The study showed that participants, considering the weak case, construed the standard of proof to be equivalent to 52.87% certainty before deliberations and 55% after deliberations. Now, this is not only slightly higher than the 50% threshold commonly associated with the civil standard of proof on the balance of probabilities, and it considerably lower than the numerical threshold that judges place on the criminal standard of proof. When surveyed, judges in the United States placed the numerical threshold for beyond reasonable doubt between 80%, and 100%, with most responding judges placing the threshold at 90% or higher. Now, the correct threshold of beyond reasonable doubt has also been theorized as equivalent to 90% based on Blackstone's ratio of it being preferable to acquit 10 guilty persons rather than convict 1 innocent person. Although many courts in jurisdictions including Australia insist it is inappropriate to assign numerical values to the standard of proof, the discrepancies between the hypothetical quantitative thresholds of lay people and judges, I think, is concerning. I mean, it's disturbing me. When reviewing similar results of a jury study conducted in New Zealand, there's a New Zealand Law Commission. A jury study conducted there found, according to Justices Robertson, Young of the New Zealand Court of Appeal, found it alarming that jurors could interpret the standard of proof for criminal convictions to be as low as 75% or 50%. Now, studies in Australia also indicated that jurors failed to understand the burden of proof. A survey of jurors who participated in 14 criminal trials held in the Supreme Court of Queensland revealed that only 39% of jurors were able to accurately describe beyond reasonable doubt. This was despite the fact that 66% of the jurors stated they understood the concept of beyond reasonable doubt. very much. Interestingly, and in contrast to the studies referred to here so far, the Queensland study found that where there was a misunderstanding about the concept of beyond reasonable doubt, the misunderstanding was usually in the form of requiring a more stringent standard of proof, that is, no doubt at all. Now, I'm going. You can see I'm going by states here. I've looked at Victoria and Queensland, but I want to jump to New South Wales. A study of jurors in New South Wales found a similar gap between jurors' subjective and objective understanding of the standard of proof. So, in New South Wales, while 94.9% of jurors responding to a survey reported they understood the judge's instructions mostly or completely, jurors' understanding of beyond reasonable doubt varied considerably, okay? Because 55.4% of the respondents thought that beyond reasonable doubt meant you were sure the person is guilty, whereas 22.9% thought it meant you were almost sure a person was guilty. It is unclear from that study which of these responses would be deemed correct. And it is reflective of the uncertainty in the common law about whether being sure or having no doubt at all means the same thing mathematically giving certainty. But look, either way, what is most concerning isn't these responses, I think, because both of them could arguably be correct, depending on how you defined the word sure. But the fact that 11.6% of respondents thought beyond reasonable doubt means it is very likely the person is guilty, and 10.1% thought it meant pretty likely the person is guilty, this widespread of opinion suggests jurors do not understand the concept of beyond reasonable doubt, as well as the courts assume, or as well as jurors themselves think that they do. Now, jurors, or in Fiji, assessors, may be incorrectly applying the concept of beyond reasonable doubt in its undefined form, because the phrase focusing as it does on the element of doubt has the unintended effect of transferring parts of the burden of proof on the defendant. That is, by placing the emphasis on a juror's doubt regarding the defendant's guilt, jurors may naturally tend to focus more on the evidence provided by the defense that establishes doubt, instead of considering the strength of the prosecution or the prosecution's proof. Now, this theory is supported by a study that is tested for the individual effects of the words doubt and proof in different definitions. Now, that study, which I'll be citing as well at the end of this presentation, revealed that when the word doubt was used as part of a definition, the threshold at which mock jurors were willing to convict a defendant was lower than when the word proof was used in the same definitions. Look, this suggests that jurors or assessors may be failing to correctly apply the concept of beyond reasonable doubt by overly focusing on doubt created by the defense, for example, and not looking at what the prosecution has been able to prove. The fact that judges themselves sometimes get it wrong indicates that the concept of beyond reasonable doubt is not as straightforward and self-explanatory as the earlier case we looked at, as Green would have us believe. There are numerous examples of cases where judicial directions have been overturned on appeal because they are deemed to be wrong. If judges cannot always get the standard correct, it seems bizarre to then assume that jurors or assessors or lay jurors and lay assessors will be able to properly understand the concept without an explanation. Furthermore, if you look back at Reynolds, as he points out, the standard of proof is not clearly definable, as some judges suggest. Then it is unpersuasive to suggest that jurors or assessors can possibly have a fundamental understanding of the concept. Even though there is some conflicting evidence, and keeping in mind there are inherent limitations of the study of mock jurors, there seems to be powerful evidence to suggest that jurors do not accurately comprehend the concept of beyond reasonable doubt, and this goes for assessors. We will now look at, if you bear with me, I'm just going to turn over my notes here. We'll now look at the effectiveness of different definitions that have been applied to the standard of proof in Australia, and we're going to look at the overseas perspective as well, okay? All right. Now, if one was to accept that jurors don't understand the concept of beyond reasonable doubt when it was left undefined by the court, the next question we could ask is whether or not jurors or assessors will take heed or understand any judicial instructions on the matter. After all, what would be the point of defining the concept to our jurors or assessors who perhaps have failed to understand or apply the concept after it is explained? Now, if, however, the explanation of the concept does affect how a juror or assessor understands the standard of proof, and especially if different opinions or different definitions produce different effects, excuse me, then it is critical to investigate how these definitions may alter the standard of proof in criminal cases. Now, studies on the effect of different definitions are, again, they're mixed, but there are a number of studies that have shown different definitions do alter the standard of proof applied in, for example, mock juries. Now, I will be citing this at the end of the presentation, but one of these sources are Cornish and Seeley, 1973. Now, they conducted a study of mock juries which involved giving jurors one of 3 instructions regarding the standard of proof that ranged from you must feel sure and certain on the evidence you have heard that the accused is guilty, to a standard associated with the civil standard of proof, that you must feel satisfied that it is more likely than not that the accused is guilty. The study demonstrated that different instructions to the jury over the standard of proof could sometimes have the opposite effect than intended in terms of increasing or decreasing the standard of proof, and that the effect of such instructions was weak. However, a more detailed analysis of their data by Kerr et al., that's looking at that previous 1976 study that I mentioned, suggests that the effects were usually orderly, frequently significant, and particularly strong when juror opinion was sharply divided. Now, despite their conclusion that the effect of instruction was weak, Seal and Cornish also found that there was a significant lower conviction rate when the jury was told they must feel sure and certain on the evidence that the accused is guilty, comparing it to when they were told to be sure beyond a reasonable doubt, which means not a fanciful doubt, but a doubt for which reasons can be given. That's a very important distinction to note. Different definitions of the standard of proof were found to be ineffective in a series of studies summarized by Kagiro, 1990. Okay, now I'm going to cite that at the end. These studies investigated the effect a wide range of different definitions and of the standard of proof, including quantified and combined definitions. Now, quantified definitions actually expressed the standard of proof in probability terms. For example, stating that the juror must be 91% certain of the truth of the plaintiff's case. Now, combined definitions, they incorporated both a linguistic instruction and a quantified probability threshold. The results of the study indicated that the quantified and combined definitions were the only instructions that were properly understood and applied by the mock jurors. Now, this implies that there was no significant difference in how jurors understood the standard of proof when instructions simply included different means of explaining the standard of proof without an associated percentage. While this may suggest that attempts to define the standard of proof are futile unless the explanations incorporate a quantified definition, something I guess it appears no jurisdiction at this stage is willing to do, there are a number of other studies which do indicate that non-quantitative definitions of the standard of proof can affect the standard applied by the jurors or the assessors if we're talking about Fiji. Now, unlike the findings of Kagihiro of 1990, Kerr et al. Of 1976, we looked at this earlier, they were able to conclude that mock jurors' verdicts are affected by a judge's instructions regarding the standard of proof, even without including quantified or numerical definitions. The study used different descriptions of beyond reasonable doubt. One did not define or elaborate on the concept any further than simply defining it is beyond reasonable doubt. And of the other two experimental conditions, one was a lax definition, which was intended to lower the standard of proof, and the other was a stringent definition designed to increase the standard of proof. Now, the lax condition required the doubt to be substantial, a substantial one or a fair one, based on reason, and one for which reasons can be given, whereas the stringent condition required the juror to be convinced to a moral certainty with absolute and positive proof. The researchers described these variations in the definition of beyond reasonable doubt as extreme, yet not unrepresentative of those in actual use in the United States. Now, the results of the study demonstrated that the expected pattern was found. The lax condition increased rates of conviction, whereas the stringent condition lowered rates of conviction. The undefined condition resulted in a rate of conviction in between the lax and stringent conditions. Now, the study also demonstrated that the definition of reasonable doubt doesn't affect a juror's weighting of the evidence or the probability at which they think the defendant or the accused is guilty. Rather, the variation of the definition appears to have the intended effect of setting the juror's decision criterion for conviction. Now, this conclusion is based on the results which indicated the definition of reasonable doubt did not affect the jurors' judgments of the probability that the defendant committed the crime. In other words, varying the definition of reasonable doubt did not appear to inhibit the jurors' ability to differentiate between their personal opinion of guilt and the legal standard required for a guilty verdict. But it did affect the rate of convictions. The researchers calculated that the variation in definition produced a difference of over 26% in the conviction rate. Now that says something. A more recent study, I'll get you the name. It was by Dami, Landrigan and Muller Johnson. Now that's a 2015 study that compared the effects of two here we go. I believe it was two reasonable doubt instructions that are based off instructions that are used in a number of states in the United States. Now, the two directions compared were abbreviated as proof willing and, I'm quoting here, doubt hesitate. The proof willing instruction stated reasonable doubt is proof that would make a reasonable person willing to act in their most important affairs of life, and the doubt hesitate instruction was stated as reasonable doubt that would make a reasonable person hesitate to act in their most important affairs of life. Now, the study revealed a significant difference in the effects of the two different definitions. The doubt hesitate instruction lowered the standard of proof applied by the mock jurors considerably, whereas the proof willing instruction resulted in a standard of proof around the desired threshold of 90% certainty. Now, although there is no consensus in the empirical evidence about whether different definitions affect how jurors apply the standard of proof, the evidence overall does seem to suggest that jurors do respond to differences in instructions. Of course, the limitations of mock juror studies should be kept in mind. And I think we need to conduct a few in Fiji. However, there does appear to be sufficient empirical evidence to suggest that in order to have a consistent criminal justice system, there needs to be measures in place to ensure that consistent instructions on the standard of proof are given. Some may argue that this system is already in place in a state like Victoria. However, the evidence suggests this is unlikely. Courts in Australia, for example, they actually avoid defining the phrase beyond reasonable doubt, yet the evidence suggests that jurors over in Australia do not understand this term and apply the standard differently when it is explained. This leaves plenty of room to argue that more consistent definition of the concept of beyond reasonable doubt is required, for example, in a place like Victoria. Okay, so moving on now, I want to look at actually defining beyond reasonable doubt. And again, I'm going to go back to Australia for this. The common law of Australia currently refuses to explain the concept of beyond reasonable doubt, okay, except in particular circumstances. And that is such as when the jury explicitly asks about the phrase's meaning, or where the defendant's counsel have improperly emphasized what amounts to a reasonable doubt. This is, by the court's own admission, an extreme and exceptional stand. Many other jurisdictions now not only permit an explanation of the phrase, but actually mandate it. Now, there's a case here, which I'll be citing at the end of the presentation, Graham and the Crown. And we see that Justice Underwood pointed out that in two jurisdictions that share common origins with Australia with respect to the onus and standard of proof in criminal cases, the United States of America and Canada, there is clear authority to the effect that a failure to elaborate on and explain the expression constitutes error. With the weight of empirical evidence suggesting that jurors do not have a fundamental understanding of the phrase as it is intended, and the findings that different definitions can have a material impact on verdicts, perhaps it is time for a state like Victorian courts and for Fiji, in terms of its assessors, to also construct a formal and relatively standardized definition of the concept. Now, should we define it? That's the question I think we're leading to here. Should we define beyond reasonable doubt? Now, one of the reasons put forward by the court for not defining the standard of proof is that beyond reasonable doubt is a phrase used by ordinary people and is understood well enough by the average man in the community. However, although studies such as that conducted in New South Wales, which we referred to earlier, suggest jurors think they understand the standard of proof, numerous studies that we've also looked at suggest otherwise. Now, my friends, the concern of the court in allowing judges to define or elaborate on the concept of beyond reasonable doubt appears to be based on a fear that any such elaboration risks lowering what is intended to be a very high standard of proof. And Justice Kitto outlined the court's concerns in a case named Thomas and the Queen. Okay, now that's a 1960 case. I'll be citing that at the end of the presentation. He said that the danger that invests an attempt to explain what reasonable doubt means is that the attempt not only may prove unhelpful, but may obscure the vital point that the accused must be given the benefit of any doubt which the jury considers reasonable. Now, the court's concern then appears to rest on a misconception, okay? That jurors understand the concept of beyond reasonable doubt and understand how high the evidentiary bar is intended to be set. Empirical research actually indicates the opposite. Now, that means it's left undefined. Jurors underappreciate how high the evidentiary bar is set for conviction. And I think it's the same for assessors. This is indicated by the studies that we've mentioned, as well as Horowitz and Kirkpatrick that I mentioned earlier, and the surveys of jurors in Queensland and New South Wales that I've already mentioned as well. These studies therefore suggest that by leaving the concept undefined, the court is unintentionally lowering the standard of proof applied by juries to a level that they would deem unacceptable. Now, this may be explained by the court's apparent failure in that earlier case of Green that we looked at to appreciate that it's left undefined beyond reasonable doubt is inherently asking the jury to assess the quality of the doubt they may have. Now, such a process, as properly acknowledged by Justice Cox, may happen unconsciously, okay? Because the fact that the court prohibits judges from instructing juries to make these kinds of internal assessments in Australia of their doubts, it doesn't prevent jurors or assessors from actually doing so. It only serves to ignore the possibility that they do. Now, I've got a very in-depth research from Tasmania, now that we're covering states, we're jumping from state to state, which I will cite at the end of the presentation. Now, that research is quite lengthy, and I think the brevity of time here, I'm going to let you know that the findings of the Tasmanian study conducted, it actually suggests that jurors need assistance understanding the concept of beyond reasonable doubt, and that they probably need more guidance than simply being told it's up to them to decide what is reasonable. The study also suggests that definition of the phrase needs to be provided even when jurors do not ask a question about the standard of proof, because the lack of a question might not be a sign of understanding, but be due to other factors that lead the jury to refrain from asking, okay? And Fiji, we've got some cultural matters to take into consideration, where some people, out of respect, don't want to ask questions of a judge or a justice. And I say that with respect, but they're things that we need to take into account. With all of these factors considered, a strong case, I think, can be made out for judges to provide a more complete and helpful explanation of beyond reasonable doubt. The evidence shows that jurors do not understand the concept when it stands alone, and the bulk of the evidence suggests this misunderstanding is not only frustrating for the jurors, but appears to have the effect of actually lowering the standard of proof that jurors apply. Now, this is the opposite of what the court appears to presume defining the concept will achieve, okay? So given that many of these studies that we've talked about so far show that rather than lowering the standard of proof, defining beyond reasonable doubt can actually increase the standard to a threshold more in line with what the court expects and requires, judges should be permitted, if not required, to provide a more elaborative definition of beyond reasonable doubt to jurors and assessors. Now, how do we define it? Again, we're going to look at some examples, okay? We're going to look at some countries here, but I want to say that whether the court should define beyond reasonable doubt to the jury or an assessor is one matter. How to do it is another question altogether, okay? It is a question that is perhaps even harder to answer too, while the empirical evidence and jurors' understanding or assessors' understanding of beyond reasonable doubt and the effect of different instructions on that understanding does not have a consensus of opinion. At least the weight of evidence is relatively clear. Okay, so let's look at England and Wales. The standard direction in England and Wales is drafted by the Judicial Studies Board and is drafted as follows. I'm going to read this out to you. I was able to capture it. Hang on a second. How does the prosecution succeed in proving the defendant's guilt? The answer is by making you sure of it. Nothing less than will do. If after considering the evidence you are sure that the defendant is guilty, you must return a verdict of guilty. If you are not sure, your verdict must be not guilty. Now, the definition essentially equates beyond reasonable doubt with being sure of the defendant's guilt. There's that word again, okay? To be sure. Judicial instructions explaining the standard of proof as being equivalent to being sure of the defendant's guilt was rejected in a case called Crown and Kavik. I'm going to cite that at the end of this presentation as well. Okay. Now, looking at empirical research, it shows that using the word sure can lead to jurors interpreting the standard of proof is as very high, almost too high, I think. In a study by Zander, it's a 2000 year study, a 51% of respondents from the general public indicated that they interpreted such an instruction to require them being 100% certain of a defendant's guilt before they could vote to convict. The same study found that 3/4 of respondents indicated they would need to be at least 90% sure of the defendant's guilt before convicting. And these results indicate that the instructions to the jury to be sure creates a standard of proof much higher than that indicated by the many studies referred to so far that we've talked about, where beyond reasonable doubt was left undefined. Now, England and Wales also feature a long-standing support for an explanation known as the important decision-making analogy, which compares a reasonable doubt to the kind of doubt which, when you are dealing with matters of importance in your own affairs, you allow to influence you one way or the other. Now, this definition has been criticized and disproved of in Canada and New Zealand for a number of reasons, mostly because such a description means it runs the risk of significantly reducing the standard to which the prosecution must be held. Now, going to the US, the Federal Judicial Center provides a recommended direction as to the standard of proof to be applied in criminal cases, and the recommended definition compares the criminal standard of proof to that of the civil standard and describes the standard as being proof beyond reasonable doubt. The direction goes on to define this as proof that leaves you firmly convinced of the defendant's guilt. The direction then goes on to specify that the burden does not require the prosecution to prove their case beyond reasonable doubt. The use of the phrase firmly convinced was studied by Horowitz and Kirkpatrick that we looked at earlier, and they referred to this phrase. That study indicated that firmly convinced had a similar benefit to the use of the word sure, in that it appears to increase the standard of proof required in a juror's mind, but not the same level as that achieved by the sure instruction in Zander's 2000 study. Therefore, although firmly convinced may bring jurors' concept of beyond reasonable doubt more into line with that expected by the court, it doesn't appear as though it is as effective as the sure instruction being used in England. Moving on to Canada, the Canadian Supreme Court held in Crown against Lifshus. Now that's going to be cited at the end of the presentation as well. It's a 1997 case. Now, the Canadian Supreme Court in that case held that an explanation of the concept beyond reasonable doubt is an essential element of the instructions that must be given to a jury. The court also approved a quite lengthy direction in that case, which begins by outlining the presumption of innocence and describes the standard of proof as beyond reasonable doubt going on to explain that beyond reasonable doubt, by saying that, is not an imaginary or frivolous doubt, and that upon it relies on sympathy or prejudice. Rather, it is based on reason and common sense. Now, you know what that's going to open to? It's going to open to defining what common sense is, and reason. But the direction goes on to distinguish between the jury thinking the accused is probably guilty and being satisfied beyond a reasonable doubt, before also acknowledging that absolute certainty is not required. The direction concludes with a summary. In short, if based upon the evidence before the court, you are sure that the accused committed the offence, you should convict, since this demonstrates that you are satisfied of his guilt beyond reasonable doubt. Now, going on to New Zealand. The Court of Appeal considered the issue of how to define beyond reasonable doubt. In Crown against one Hala, which I'll cite at the end of the presentation, the court gave an explanation of beyond reasonable doubt that they encouraged other judges to follow. The explanation they gave, borrowed in part from the Canadian explanation given in the Lifshus case, began with the presumption of innocence and equated beyond reasonable doubt with being sure that the accused is guilty. Now, the court did not make the explanation mandatory for other judges to follow, and noted that no single formula was required. The court stated it would be sufficient to simply make it clear that concept involves a high standard of proof. This is a common thread in many jurisdictions, okay? While judges are often provided with model directions, most jurisdictions allow for flexibility, require only that the key concepts such as the standard and onus of proof be stated. Now, looking at quantified definitions, there does not appear to be any common law traditions that advocate or even permits judges to explain the standard of proof in reference to a percentage or quantified measure of certainty. Such a radical step is, I think, unlikely in a state like, for example, Victoria, considering how this Australia has already appeared to be lagging behind other jurisdictions in even attempting to explain the concept to their jurors using language alone. Such a move would also be in direct contradiction to the common law, the position of which is well put by Chief Justice King in Pahuja, which we mentioned earlier, that the adjective reasonable in the expression reasonable doubt does not denote any particular degree of strength of the doubt. It is qualitative, not quantitative, in meaning alone. That is, a person may be 99% sure of the defendant's guilt, but if that 1% of uncertainty is a reasonable doubt, then the jury must acquit. And look, mathematical probabilities are generally regarded as inappropriate for judicial fact finders because the kind of decision making that is involved in that exercise is undertaken via a process of global assessment of an entire complex array of information, and such a process cannot accurately be simplified to a simple percentage of numerical threshold. The Victorian Court of Appeal also rejected the notion of using percentages to describe the standard of proof in Crown against Kavik, a case that we mentioned earlier. And despite the obvious opposition, there is still something to be said in favor of introducing a numerical or quantified expression as part of the explanation of beyond reasonable doubt. As I discussed earlier, definitions that include quantified elements in them were the only definitions that had the desired effect on jurors' standards of proof in Kagiro's 1990 case series of studies. Now, this indicates that quantified definitions are the most accurate and easily understood way to communicate the standard of proof to jurors. Obviously speaking, such a step would be a significant departure from the common law, but it is something that should be considered as a means of increasing juror understanding of how high the understanding of proof is intended to be, and to help ensure that a consistent standard of proof is applied across our cases. Now, in conclusion, I'm going to say that, look, nobody doubts the importance of criminal standard of proof to the fabric of society through its function as a key protection of an individual's liberty against the power of the state, okay? But it is surprising, then, that the Australian courts persist in their assumptions about jurors' understanding of the phrase beyond reasonable doubt. And I think the same can be applied to Fiji with its assessors, because despite the ever-increasing weight of evidence to the contrary, numerous studies have demonstrated that jurors just don't understand or have a natural understanding of the phrase beyond reasonable doubt, and that they do not apply the standard as it is intended to be applied by the courts. Studies have also demonstrated, as we've discussed, the powerful effect on the standard of proof and on verdicts that different definitions can create, and that in contrast, again, the assumptions of the court can actually increase rather than decrease the standard of proof applied. Doing so would replace assumptions with evidence and bring, I think, a country like Australia up to speed with other jurisdictions around the world. When charging the jury, judges in Victoria have actually stopped at reasonable doubt for far too long, and I think it is now time that they move forward. Thank you for your time.